need a conservatorship. So obvious, but not one of them has said, hey, we need to go back and look at what happened 13 years ago when not only did her court-appointed attorney tell the judge that Ms. Spears could not retain counsel, even though she had retained counsel, but he went a step further and said, she doesn't even get to have the paperwork. She's not this is in writing. I mean, I couldn't make this up. I'd lose my state bar license in a New York minute. He actually, the court-appointed attorney actually signed a document, a court order that said that Britney Spears could not receive the paperwork that was filed in the case to conserve her. And then he actually agreed that she would not be allowed to see any other lawyer. I mean, this is like you couldn't even, if I was in Hollywood and I wanted to make a screenplay, I don't think that I could get anybody to believe what was going on. So the people that we need to get in touch with are the people that can effectuate laws and create a checks and balances on the judiciary, on the judges, commissioners, and the people presiding. We are not making progress poking at or looking at just the guardians and the lawyers. The problem is higher. And I know this because I'm watching it. I've observed it. I've documented it. I will never say, if you put me under oath, that any of the judges I've appeared in front of is taking money or in any way economically enhanced in a way that would give them an incentive to separate you and your parents. In fact, some of the most egregious cases I have been involved with are cases that involve very little or no money whatsoever. It's disgusting what's going on in some of these cases. But when judges have to rely on court-appointed attorneys, they create this sort of a swamp, basically. And the judges are the ones doling out money. So who's showing
2
up?
minutes.
How many?
2 minutes.
2 minutes. Okay. So the last thing I want to part with, and this is so incredibly important to all of our movement, we have to be excellent to each other. Please stop attacking me. Please stop attacking judges in terms of calling us out as criminals, but mostly stop attacking each other. We don't have to agree with each other's ideas and with each other's in terms of recommendations, but we have to stop attacking each other because that is what's going to create the room for ignoring us. We need to be heard on the highest levels possible, which is the legislative level. So I thank you for your time. I will go through. I see a lot of questions. I'm not saying that I have all of the answers. I'm not even saying that I understand everything that's going wrong, but as a boots on the ground, as the attorney that's been practicing, who went to law school to be a guardianship and conservatorship attorney, I can tell you that what I'm seeing in terms of incompetence is horrifying. So thank you very much, Dr. Sugar. This has been a wonderful, wonderful webinar, and we appreciate you very much. Thank you.
Thank you. That's really lovely to hear, and I appreciate everyone who's spoken. We're reaching the end of our time, and I wanted to reiterate something. The reason that we've worked so hard to put this together is because this entire issue of the probate part of equity court, and today we've heard about family court, we haven't heard much about divorce, but the probate section of the equity type courts across the states in the United States is a very complex, multi-tiered, multifaceted, just incredibly opaque system. And I wanted to present opinions and perspectives from a variety of viewpoints today. I might not agree with everything that one or more of the presenters say, but that's fine. However, we need to listen to all those viewpoints to form our own intelligent opinions of how to move forward as a movement. Not everybody's going to agree with everybody else. There's some people who will never accept that we should be content with stupid judges. I'm one of them. I don't know whether to be more upset about a stupid judge or a corrupt judge. I have a feeling I'm more upset about the stupid one, but because at least you know where a corrupt judge is going. On the other hand, at the end of the conference, which will be in about 35 minutes, I will hopefully have a link, if not today, then on the website tonight, of a follow-up web meeting on Zoom for anybody who's been on on either of these two sessions, to have a free and open discussion, because there was a problem with chat and Q&A. I take responsibility. I promise next time I'll have them all open, but I can't change it in midstream. So I want to thank everybody who's spoken so far and introduce my new friend, Zina Crenshaw-Logel, who is coming at this from a very, very different universal angle. Welcome, Zina, and the floor is yours.
Thank you so much, Dr. Sugar, and certainly a pleasure to be here. I think what Attorney McCarley has described as the swamp is what I would describe as organized U.S. legal system abuse. And the fact that I'm talking in terms of what's organized, deliberate, whereas Attorney McCarley talked in terms of negligence, incompetence, and cronyism, suggests that we may be, a very different we may have very different perspectives about, the conservatorship and guardianship abuse that this conference has been addressing. But actually, negligence, incompetence, and cronyism is all part of organized U.S. legal system abuse. It's not just a matter of garden variety criminal activity, bribery. It all factors in there. So hopefully, through my presentation, that'll what it exactly entails will become a bit more clear. But conservatorship and guardianship abuse in America supplies some of our country's most blatant examples of organized U.S. legal system abuse facilitated by unchecked judicial misconduct, which of course includes incompetence. Now, that's a mouthful, so let's try to break it down. Organized U.S. legal system abuse is a very deliberate effort to deprive one or more parties to a legal proceeding of a fair and impartial outcome. That's what you're denied, a fair and impartial outcome. So the unfairness and the improper bias or the lack of impartiality, these are not just things that happen. They are, in the case of organized U.S. legal system abuse, they are exactly what was intended. And of course, if that outcome is facilitated by judicial misconduct, the presiding judges or judges have helped make this organized legal system abuse happen. But again, in a very deliberate way. The judges or judges, the judge or judges would have shown an obstinate indifference to binding law. So this is not just, they're stupid and, they had a bad call. There would be evidence that there's just a determination, a commitment to deny you a fair and impartial resolution, to comply with binding law, not just my impression of how things should go, but binding law. Now, if that were happening, the judge certainly would have violated some applicable code of ethics, some code of judicial conduct. In addition to being unethical, his or her conduct may also constitute legal error, something consequential as opposed to harmless error. We've all heard the term reversible error. This judicial conduct may be illegal under civil law. It may be some civil law where, they're something that can be addressed through civil litigation. The conduct could even constitute a crime or involve criminal activity. There are federal statutes that criminalize deliberate violations of rights. And of course, then you have the garden variety bribery, these sort of concepts. But no matter what makes the judge's conduct wrong, it's unchecked when that wrongdoing is never officially and properly identified or goes without appropriate repercussions, something that perhaps is punitive or restorative in nature. Now, certainly this symposium has helped make clear that obstinate disregard of probate, conservatorship, or guardianship law can involve violations of fundamental human rights, even supposedly inalienable human rights. In America, we call them the right to life, liberty, and the pursuit of happiness. I've detected and I've been full-time good government advocate focused on U.S. legal system abuse, or the U.S. legal system full-time since 1998. Before that, I was a civil trial attorney. But over the course of, how many years is it now, decades, I've detected a lot of skepticism about the usefulness of resort to the United Nations, because in recent history, it was the United Nations was unresponsive to many human rights violations perpetrated through organized U.S. legal system abuse. What I've tried to make clear over the last 6 or so years is that unresponsiveness, unresponsiveness of the United Nations can be reconciled with some direct and de facto determinations that were made by the UN Human Rights Council in response to a January 2018 submission by Opt-in USA, which is a judicial accountability campaign that I helped administer. The UN Human Rights Council confirmed in October of 2018, again, in response to the January 2018 submission of Opt-in USA, the Council confirmed that America lacks effective avenues of redress for allegations of organized US legal system abuse facilitated by unchecked judicial misconduct. Wow. You know, to make that type of determination about a nation of the caliber of the United States of America. But that is the determination that was confirmed in October 2018. According to the International Commission of Jurists, for our avenues of redress to be effective, they must be prompt, accessible, available before an independent body, and lead to reparation, and where applicable, to cessation of the wrongdoing. And of course, these are complex considerations in a world of competing social challenges, competing budget demands. However, it's access to an independent body that is the central concern of the national grassroots community that's contending with organized U.S. legal system abuse. Writing for Opt-in USA, I explained that all, and this is, I'm quoting, I explained that all parts or phases of America's legal system that are tasked with judicial oversight are so deferential to judges whose ethics we question that for virtually all practical purposes, these alleged sources of judicial misconduct became final arbiters of our rights and freedoms at issue. Now, this is after, again, since 1988, observing trends, observing cases, observing outcomes, from the perspective as a social justice advocate and a civil trial attorney that focused in on complex personal injury litigation, meaning it wasn't just a bunch of car accidents. It was, looking at civil rights, constitutional rights, coverage issues, and we wrote that letter, or I wrote that letter on behalf of Opt-in USA in July 2016. What I shared with you was a near verbatim quote of my letter to the U.S. Assistant Secretary of State for Democracy, Human Rights, and Labor, as well as to the permanent representative to the UN. Opt-in USA was seeking their help in persuading the White House and our Justice Department to address what at the time 38 non-governmental organizations had described by a sign-in letter as unchecked judicial misconduct. And it's still heartbreaking for me to read those letters and the life diminishing, sometimes life ending harm that they describe. But the letters went pretty much unanswered. I think there may have been a couple of letters where, rather boilerplate, but the U.S. Justice Department did indicate that they were looking into the matter, and nothing explicit came out of it. So fast forward to January 2018 and Opt-in USA submission to the UN Human Rights Council, which I mentioned earlier. The truth of the matter is Americans have gone to the UN seeking help from literal persecution through our own legal system because we've simply gotten too close to nowhere combating the underlying judicial misconduct in America. And yes, it's true. The UN is not going after who we think are the ruthless and the rogue lawyers, conservators, guardians, judges, and other government agents that we contend are violating our rights with impunity. But that's America's job. What we're not quite, it seems, appreciating is that within the context of mandates forged by its member states, which include America, the UN is helping us push America to do that job. Our predicament, the predicament that we've heard described throughout this symposium, our predicament mirrors America's failure to reasonably protect us from human rights violations committed by US government officials. And again, the UN Human Rights Council has confirmed. In fact, it was a panel of experts that comprised the council's working group on communications, experts on government sanctioned, government perpetrated human rights violations. And the United States, therefore, the failure to have effective avenues of redress translates into their failure to adequately protect us from human rights violations committed by US government officials. And that violation, that failure violates multiple human rights treaties, most notably America's International Covenant on Civil and Political Rights, and that's the ICCPR, which the UN Human Rights Council helps enforce. So what I'm hopefully making clear is this distinction between the individuals that in a legal proceeding, you contend were violating your rights, that their conduct rose to the level of not only being error, or anything that could be redressable through domestic avenues of relief, but actually constituted a human rights violation. That's one thing. We're talking about America's failure to protect us from that behavior, which begins by providing us effective avenues of redress. They don't have to guarantee that we win. They don't have to guarantee that anyone is going to necessarily agree with our assessment of the situation, but we have to have what's a process that's prompt and accessible and fair and impartial, and that can lead to reparations, relief to the extent that we're entitled, and could, where applicable, actually in the wrongdoing. Now, we can say to the United Nations, thanks, but no thanks, and just keep prodding US officials without international outcry. Because again, it's one thing to challenge the lawyers and the judges and the other people who, we think directly violate our rights. It's another thing to try putting their usurpation of the US legal system on trial. Advocates have presented, over the years, some of the most, effective just tremendously talented, committed advocates imaginable, have presented class actions. They've alleged racketeering. We've tea partied. We've occupied. We've debated whose life does or does not matter. We've had signature drives. We've had phone drives. We've had fax drives. We've had email drives. And in the meantime, our decades have passed. Some of us have not even lived long enough to realize relief. And, in the meantime, our family and friends are worrying that we've taken leave of our senses. In the land of the free, we're freely called conspiracy theorists. And this is by people who clearly fear government retaliation for almost any level of discontent, of dissent. I don't get, I don't get that. Fearing your government, fearing standing up and challenging these issues, but on the other hand, contending that the articulation of them is in the province of conspiracy theories. Okay, by contrast, concepts like weaponization of legal systems and persecution with impunity are the stuff of international human rights experts. These UN bodies, they look at evidence and they come to the decision of, oh no, this is just subterfuge. This is an abuse of legal process. This was arbitrary. They're comfortable with these concepts. Whereas we are trying to get domestic bodies to, to basically confirm these dynamics, weaponization of legal systems. And we, in this country, we talk in terms of due process violations, perhaps conspiracy, racketeering. Um, Again, the international human rights community addresses those dynamics with regard to countries around the world all the time. It's just that the United States is not usually the subject of the analysis. But in any event, regardless of what we think about the United Nations and resorted to the United Nations, I want to emphasize that one thing that helps provoking public outcry, whether you're trying to appeal to Main Street America or to the community of nations, and that is identifying national patterns of judicial misconduct that are unique to organized U.S. legal system abuse. Conduct that adheres to a pattern likely seems deliberate, especially distinct, objectively discernible patterns such as judicial engineering and the third degree, which are bedrocks of opt-in USA. The judicial engineering is a very unique form of judicial misconduct. And the third degree is an objectively discernible pattern of judicial misconduct. It has very distinct outcomes, and it has very distinct objectively discernible modalities. If organized U.S. legal system abuse didn't evidence judicial engineering and the third degree, I don't think, as Opt-in USA proposed, I don't think the UN Human Rights Council would have acknowledged the phenomenon of organized U.S. legal system abuse. But what's troubling is that the National Forum on Judicial Accountability that I help administer has not had anyone request training to align their difficulties with judicial engineering and the third degree since those patterns were first identified. And at this point, that's almost 6 years ago today. Um, I don't think time is going to permit me to detail the particulars. But the council, the UN Human Rights Council's requirement that complainants prove gross patterns of human rights abuse is proving problematic for Opt-in USA. By implication, the Trump administration represented to the UN Human Rights Committee. Now that's different than the council. The UN Human Rights Committee is the treaty body, the UN's treaty body that deals with enforcement of the International Covenant on Civil and Political Rights. And the Trump administration represented that during years 2015 to 2020, and again, by implication, the Trump administration represented that organized US legal system abuse was not among our country's most critical and relevant human rights issues. They arguably conceded that it was critical, but just simply not among our country's most critical and relevant human rights issues. That's a great concession. They were dealing with that time with this determination by the Human Rights Council that our country is not providing effective avenues of redress. And the Trump administration basically said, well, yeah, that's a serious problem. But we got other more serious problems to deal with. Um, and those problems are being identified every day, and it doesn't include things like weaponization. It's not reaching weaponization of the U.S. legal system abuse with the impunity on the part of judges who are facilitating that outcome. But what's worse is that the Trump administration and represented that as of January 15, 2021, America was not considering acceding to the optional protocol. Um, the optional protocol, the name Opt-in USA is a takeoff from this optional protocol, which is a provision, a treaty provision that would allow Americans to seek assistance on an individual basis from the UN Human Rights Committee and sidestep the UN Human Rights Council's jurisdictional hurdles. Hopefully you're following me. If we could go directly to the UN Human Rights Committee, all I'd have to establish is that rights, my human rights were violated under the color of law. The UN Human Rights Council can only get involved if we establish a gross violation. And in my opinion, that was established. So we're going to be addressing this notion that we didn't establish that this was a gross problem, and what's troubling is, what do they mean by that? Because if 10,000 people are directly subjected to organized U.S. legal system abuse, and the repercussions are felt exponentially for generations to come. That's the evidence we presented to the UN Human Rights Council. So what are they saying? Are they saying we need to pull together 10 million examples and have prima facie cases, that establish this organized U.S. legal system abuse? I'm not sure many countries could pull that off. So it's very troubling that while the United States is a party to these human rights treaties, they won't let us as private citizens go to the UN and directly enforce them. Citizens of China, historically authoritarian countries, some of them allow their citizens that option, whereas U.S. citizens don't have the option. And it's very troubling. If I was a prisoner, a Chinese prisoner, I could go to the UN Human Rights Committee and allege that I was being tortured. And if I prove that, the UN Human Rights Committee could issue a determination that the Chinese government is engaging in torture and must cease and provide me relief and reparations and compensation relief for my suffering. No American citizen can do that. And I think it was the head of Human Rights Watch that said, as a result, the United States human rights treaties are, pretty much a sideshow because we can't enforce them.
5 minutes.
Okay, I'm just about done. The ICCPR contemplates our country doing whatever it takes within appropriate legal frameworks to get relief for targets of protracted U.S. legal system abuse. And for many reasons, I submit that the ICCPR may be our best chance for vindication, and for people with dated causes, the only chance, because the ICCPR will allow a country to suspend statute of limitations, the, what is it? I can't remember all the different doctrines that could put a time limit on our ability to present our cases. They can be suspended for through the ICCPR, and they can not only identify the nature of what has happened to us, who the culprits are, arrange for the appropriate retribution and relief. In the meantime, I've been reaching out to the UN special rapporteurs who could be a great ally in individual cases. They can help us raise the volume of our plight, and that's exactly what we need. But as of now, we're not harnessing as best we could our own collective strength. This morning, I encountered a quote from the Opportunity Agenda, which is a nonprofit organization helping advocates address some of America's biggest societal challenges. And the quote is, narrative changes do not happen on their own, particularly around contested social justice issues. It typically results from a sophisticated combination of collaboration, strategic communications tactics, and cultural engagement, all attuned to key audiences and societal trends. We need a change from the narrative, the national narrative, that our concerns are not among America's most critical, but it's not going to happen. That narrative change is not going to happen willy-nilly if we're not more strategic in how we're creating public awareness of these issues. Thank you.
You know, I'm so impressed with everybody who has spoken over the last 2 days. I'm blown away. I think we've accomplished our goal. We set out to have a discussion, a wide-ranging discussion from a number of points of view. We've looked at this from the point of view of the individual victim, the individual family, from the point of view of attorneys, academics, litigators, no judges, I might add, but close. We've had the clerk of courts, which is right next to the judges. And I think we've all gotten a great education and learned an enormous amount. I think we all need to let this percolate in our brains. And if you look at the chat, I have arranged a Zoom meeting that everyone is welcome to join. The links are on my webpage at www.aapg.net. Please join us Thursday at 3 p.m. for a follow-up meeting after we've had a chance to mull this over and maybe get an idea of our next direction. On behalf of everyone who's spoken, on behalf of our wonderful audience, we've had over 100 people in the audience at all times since last night. That's the biggest crowd I'm aware of ever to come to one of these, and I appreciate it. I wish you all wonderful good health and good luck. And my parting remark is very simple. We're all valuable. We're all important. We all have rights. Stay away from places that take those rights away. Thank you and goodbye.